Yeah, and I've seen a couple horror stories in my days where
Same.
they just didn't get they either didn't want to cause an argument between spouses. Maybe they weren't quite getting along as much as they were hoping, and so having this conversation of a split blended family and who gets what is something that was so uncomfortable that they just wouldn't do it. An extreme example was there was an old friend of mine whose dad had this property up at the lake up in Island Park, and 3 generations they've owned that cabin. And the dad wanted to buy the other brothers out, which is a good idea. I mean, don't leave an asset split between different families. It causes all kinds of problems. So he was consolidating ownership, and he got the ownership consolidated to just under him. But then we couldn't get him to finalize the estate planning to where his estate would go to his children, not to her, and if he passed away first, to her and her children. And COVID happened, and he passed away first. All of his accounts, all of his property, there was generations of firearms that grandpa used and dad used that I grew up hunting with, and there's this cabin that's been in the family for 3 generations, all gone to this spouse who had been married, I don't remember, it wasn't a few years, this other spouse, got all the property, immediately locked everybody out, sold it, and then moved out of the area. And then she died maybe a couple years later, but completely disinherited his children because he wasn't willing to have the uncomfortable conversation that just needed to happen. And the way that really hurt all of his children. Just this week, I had a conversation with a guy who his dad owned some farm ground in the area with his brother, or his dad's brother, and they couldn't agree on how to transfer or share the property or deal with the property before his dad and his uncle passed away. And so they basically created a trust and said, well, the kids can figure it out. Well, now you've got 5 kids on either side of this family that are all fighting over the same property, and it's developable property at this point. And so some of them are like, well, I want the frontage property that has the most value, and you'll get the part in the back that there's no road access. And so there's fighting over like just how to deal with the property. And so, I think one of the things that I encourage people when I'm talking to them is like, please don't leave real estate to your children unless it's a consolidated ownership piece, especially if it's something like a cabin property or big undeveloped property. I've seen more than not just so many problems with families getting torn apart because of assets that are hard to split. So I don't know if you've had a lot of the same experiences.
Yes, land is very difficult. I always tell clients that if you want to hold land and pass that to multiple owners, that is way more difficult than me taking a $2 million account with 2 kids or 4 kids and giving them $1 million or $500,000 each. It's so much easier. And so if you have land and it's not going to just be sold outright or given to one child, or the one child able to step up and take that as his share, then it just can be very difficult. And you've got to set out very clearly how you want that to be distributed. Another difficult thing that I've seen is with regards to beneficiaries on accounts. And this is where I try and work with the financial planner to make sure this doesn't happen. But I've had a situation where, getting back to that, living with a partner, that had an individual that had named his spouse, or not his spouse, his partner as the beneficiary on his retirement accounts. And just before he died, he had received some documents from the retirement account saying you have an account and you don't have a beneficiary on there. And so he named his son as the beneficiary on this account from the retirement. And verbally, he had indicated, I want...
So estate planning wise, it was supposed to go to the spouse, but then he put the beneficiary as his son on the account itself. Yeah. What
ended up happening, though, is he didn't do an estate plan.
Oh, okay.
He refused to do an estate plan, and verbally had communicated, I want $100,000 to go to to my partner, and then some other money to go elsewhere, and then everything else to go to my son. And that had been communicated verbally, but just refused to do an estate plan. Didn't want to face it because he didn't think he was ever going to die.
Yeah.
Honestly,
Yeah.
I talked to the son afterwards, and he just didn't think he was going to die. And when the doctor gave him, and there had been some discussions between the son and the partner and him with regards to how this would go. And literally the day before he died, he had gotten a diagnosis. He got a week to live.
Wow.
And he told his son, look, I'm going to tell you what I want. And so he told him, this is how I want things to be distributed. And it was all done verbally. And it was kind of understood, at least from my client's perspective. It was all understood what was going to happen. And then he ended up passing away. And as we went to probate the estate, it was unclear who the beneficiaries were on their retirement at that time. And so it came out that when we went to contact them, that there was actually 2 retirement accounts. And he had put his son as the beneficiary of the one that was worth $700. And the one that was worth $700,000 was the one where the partner had been listed.
Oh.
And so in his mind, he was naming his son.
Oh, geez.
But just there was some confusion about how many accounts there were. And
I think people misunderstand that too a lot, where they're like, well, my will says that this is what's going to be split. And they don't realize that the will doesn't matter when it comes to retirement accounts specifically, because whoever the beneficiary is listed on that account, that's where it goes.
Right.
Period.
Yep.
Doesn't matter what your will says. Doesn't matter if it was a trust. Doesn't matter. The beneficiary is where that goes. And so.
Yep. Bank accounts, retirement accounts, stocks, bonds, CDs, anything where you list a beneficiary on them, that's where they go. And there was another one where a grandma or a mother had a daughter that had been adopted out very young, and she had named the daughter that she had adopted out as the beneficiary, but her will said everything goes to her grandma, or to her granddaughter. And so the granddaughter probated the will and then went to collect everything, and sure enough, she wasn't to get it. It was to go to this other.
Yeah.
And so it wasn't what our understanding of how things were to be distributed, but you're right, whoever the beneficiaries are. And one issue with that I often run into is on a lot of accounts, some of the accounts will just say, these are my primary beneficiaries. And I don't know, I guess I'd like to get your input on this. On some accounts, I've had experience that they'll be able to designate if the primary beneficiary has been deceased, then it will go to the deceased individual's children, as opposed to just going to the other primary beneficiaries.
Well, it depends on if they've checked the box, if it's per stirps or not. Yeah.
Okay.
How that kind of goes down the path.
And on most accounts, can they make that choice? Because I've had some come back to me and tell me that they can't, and I've said, well, because usually in an estate plan, you're wanting that if your children have passed, you're wanting their share to go to their children. And so you just got to be real careful that you work with your financial planner or whoever's dealing with your accounts to make sure if that's what you want and you're not naming your trust as the beneficiary, that you make sure that they check that.
And I think a little bit of that issue is laziness on the part of somebody who's managing an account, to be honest. I think there's some laziness in there because, for example, if I have a husband and a wife, a couple, and they're each other's beneficiaries, and one of them passes away, then you should be making sure that you're updating all of the beneficiaries at that point. You know, not just contingent beneficiaries or how that's going to flow from there, but changing all the primary beneficiaries and going back through all the accounts and updating that so that it doesn't still have a deceased person as a primary, and then they're trying to figure that out. So I think that's really important that, as part of the review process that you have with clients, and as any major life event happens, that those things are done.